Companies Act, Section 454A, Penalty for Repeated Default. Section 454 of the Companies Act, 2013 provides a powerful legal mechanism to deter habitual or recurring violations by companies and individuals responsible for compliance. This section ensures that once a penalty is imposed for a default under the Act, the same offense must not be repeated in the future, otherwise, strict financial consequences will follow. It enhances discipline and accountability across corporate governance functions. When does Section 454 apply? A company, or an officer in default, or any other person involved in compliance has previously been penalized for an offense under the Companies Act. If such an entity again commits the same default, within 3 years from the earlier penalty order, then the stricter penalty rules under Section 454 are triggered. The prior penalty order must have been issued by an adjudicating officer or a regional director. This ensures that there is a formal legal record of the first penalty. Nature of the enhanced penalty. The penalty amount becomes twice the penalty prescribed for that offense under the relevant provision of the Act. This applies for second offense, third offense, any further repeated offense within the 3-year window. There is no upper limit or discretion here. The doubling of penalty is mandatory in every such repetition. Objective and justification. A. To discourage recurrence of non-compliance, once a company has faced a penalty, it is expected to correct its internal systems. B. To promote continuous compliance. Compliance cannot be temporary or selective, it must be ongoing. C. To hold officers personally accountable. Officers cannot take compliance lightly after being penalized once. D. To protect stakeholders. Repeated violations could negatively impact shareholders, creditors, employees, and the public. E. To reinforce the seriousness of corporate law obligations. Compliance failures are treated as ongoing misconduct if repeated. Scope of violations covered. This provision applies broadly to any default under the Companies Act that has an adjudicated penalty and is repeated within 3 years is committed by the same responsible individual or company. It includes defaults relating to filing delays, disclosure failures, governance lapses, procedural non-compliances, financial reporting defaults, and many other statutory obligations. Effect on corporate governance and compliance systems. Strengthen their compliance monitoring framework. Appoint efficient compliance officers. Maintain statutory records meticulously. Rectify internal process weaknesses after the first penalty. Conduct regular audits and legal reviews. This provision promotes a culture where companies proactively prevent recurrence rather than react after penalties. Consequences of ignoring Section 454A. If a company repeatedly ignores its legal responsibilities, costs multiply substantially. Directors' officers may face disciplinary action. Company reputation and creditworthiness suffer. Legal and regulatory intervention may intensify. Risk of further severe actions under different laws increases. For more details, contact us.